Online scam artists sometimes use email addresses that contain someone else's trademarks, but where that trademark appears only in the username portion of the email address and not in the domain name, then filing a domain name dispute is not going to do the trademark owner any good. That's what happened in the case I'm talking about here. The case involved a trademark owner known as VFS Global Services out of the United Kingdom. According to a decision in the case filed by VFS at WIPO under the UDRP, the Uniform Domain Name Dispute Resolution Policy, VFS offers services related to the filing and processing of visa applications. The decision says that VFS provides its services to diplomatic missions in 144 countries, and that it has processed more than 248 million visa applications. Now, VFS uses the domain name vfsglobal.com, and the decision cited trademark registrations for VFS and VFS Global that were registered as early as 2007. The respondent in the UDRP case, or the entity against which VFS filed its complaint, was identified as David Killam in the United States. And VFS said that he used the email address vfsglobal@visasdept.com, DEPT apparently being an abbreviation for the word department. Now, it's unclear from the decision exactly how or where the respondent may have advertised or displayed this email address, but the decision says that someone on behalf of VFS contacted the respondent at this email address for information about visas in Canada and was ultimately directed to a website to make payment for a visa. And the website falsely appeared to be a website for VFS, although the UDRP decision does not specify whether the website used the disputed domain name visasdepartment.com or something else. In any event, to stop this confusion, VFS filed a complaint under the UDRP against the respondent for the domain name that was being used in the email address vfsglobal@visasdepartment.com. And although it seems obvious that the username portion of the email address was identical or confusingly similar to VFS's trademarks, the panel pointed out that the UDRP only deals with domain names, not with email addresses. Specifically, here's what the decision says. The panel readily accepts that the email address vfsglobal@visasdepartment.com is likely to be mistaken for an email address associated with the complainant, or at least the VFS group. Given the way it is being used, ultimately to connect visa applicants to a fraudulent website to extract money from the applicants in the false belief that they are paying for a visa, the panel accepts that the respondent appears to be using the email address in connection with a fraudulent enterprise. Unfortunately, the policy is concerned with the abusive registration of domain names, not email addresses. The domain name at issue here is visasdepartment.com. It is this which must be at least confusingly similar to the complainant's trademarks. Disregarding the .com GTLD, the disputed domain name consists of Visas Department. It is not possible to recognize the complainant's trademarks in that expression. It neither looks nor sounds like VFS Global. So as a result, because the very first element of the UDRP requires every trademark owner to prove that the disputed domain name is identical or confusingly similar to a trademark in which it has rights, the panel denied the complaint and refused to transfer the domain name to VFS. Here's how the decision concluded. With very considerable reluctance, the panel finds that the complainant has failed to establish that the disputed domain name is confusingly similar to the complainant's trademark rights. The policy is limited to resolving disputes about the registration of abusive domains. Accordingly, the jurisdiction of this panel is limited to providing a remedy in cases of the abusive registration of domain names, also known as cybersquatting. As the complainant has failed to establish the first requirement under the policy, the complaint must fail. So, although unfortunate for VFS, and of course any victims of the respondent's apparent scam, which may certainly have included people who understandably do not appreciate the distinction between usernames and domain names and email addresses, This decision is an important reminder that the UDRP is a narrow policy that addresses only domain names and not email addresses. While an email address used by a respondent might provide important evidence in a case, ultimately, the domain name against which the complaint has been filed must be identical or confusingly similar to a complainant's trademark rights. Now, this does not mean that using an email address in a deceptive or fraudulent manner is appropriate or even legal. It's just that the UDRP is not the right enforcement tool in every case. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.